Yeah, good day, dear esteemed viewer, and welcome yet again today in our today's episode of Citizens and the Law on ABS Television, Channel 24 Oka. Citizens and the Law is a program aimed at letting the citizens know their rights, defend these rights, and become law-abiding citizens. In our today's edition of Citizens and the Law, we are going to look at responsibility to invited guests. And I have with me here in the studio a gentleman from the Nigerian bar who is going to get all the I's and T's dotted and crossed vis-a-vis the provision of answers to all the questions. With me here in the studio is Barrister B.C. Anye. Counsel, welcome to the studio.
Thank you very much.
I am the anchor of this very program. Jude Mascot Biagu is my name. Counsel, you've had the topic. We just have to get started. But one thing I want to let our people out there know is when you find yourself somewhere, in somebody's house, in public area, you are there. Either you want to go there or you were invited to be there. There are conditionalities. In some areas, you may enjoy some remedy in case something happens. In some areas, you have nothing. You are just on your own. So the lawyer is here to let us know which is which. So, counsel, number one question is this. Who is a guest and an occupier?
All right. You just said earlier that most times you find yourself somewhere, you just wonder whether you are invited or not. But generally, when you're addressing the populace and then you mention guest, what often comes to their mind is the idea of someone extending an invitation to them. So for them, when an invitation is extended and they appear to find themselves somewhere, they are not regarded as guests. But in law, the term guest is not limited to what I just explained. It covers a wide range of spectrum and includes categories of persons who find themselves in a place, whether they are allowed to be there or not, so far as they are in a premises in its widest meaning. Premises in its widest meaning. Because to you, what you may regard as a premises may not be what the law calls it. That is why the person who finds himself there, the law will still regard him as a guest in your premises. Now, for an occupier is a person who has the possession, use, and occupation of a premises, whether for a temporary period or for a long period, provided you have the use and possession of the place. Worthy of note in discussing who an occupier is that there may be one or more of occupiers occupying a particular premises, or even more than two, depending on the circumstances of the case. For example, when you have a block of flats, each of the tenants there can be described as occupiers. Secondly, like we said, a tenant can be an occupier, and thirdly, you may be an occupier even though you are not present in that particular place. So these are just the few.
You may be an occupier even though you are not present.
Physically present.
How? Can you go further to explain?
For example, you own a premises.
Yeah.
And you don't usually reside there. You stay outside the place where the premises is situated and lying. You are the owner and also the occupier because there is no one there. But for example, when you own the premises and you put tenants there, you are the owner and the tenant is the occupier. So in such a situation, you own the premises and you are the occupier, but you're not residing there. So you are the occupier and you're not present. So that's just a situation where you...
Okay, the landlord can bear a dual name. He can be an occupier as well as the owner. And
yes,
the tenant is just the occupier.
Yes.
Okay, now, can you just go directly and get these two things, invitee and a visitor, differentiated?
Invitee and a visitor.
Yeah.
From the word invitee, conjures up in one's mind someone who has been invited to a premises, either by the occupier of the premises. Once you're invited and you come there, you are now an invitee. But an invitation could come expressly or impliedly. I'll address impliedly. You have a shop, you're selling goods. People know that ordinarily why you open this shop is for them to come there and purchase goods. There's an implied invitation extended to people there. So when they come, they are invitees. So in that situation, there's an implied invitation. Then the next one is a visitor. What really comes to my mind is Section 7 sub 2 of the Law Reform Torts Law 1961, which applies just to Lagos State. It says that a visitor is someone who, at common law, finds himself at your premises for one reason or the other. So under Section 7 sub 2 of this law, such person qualifies as a visitor. But there's a situation where, excuse me, there's a situation where someone may find himself in your premises. He doesn't have your invitation, but he has your permission. If such a person finds himself in your premises with your permission and not invitation, that person is a visitor.
What kind of permission? What do you mean by permission?
Let me give you an example. There are some persons who, by operation of law, are entitled to be in your premises. Someone like a health inspector. You unnecessarily do not need to invite him, but he comes because there's a duty imposed on him by the law to be there. So there's a permission in that instance, and when he's there, he's a visitor.
Should there be any remedy for such visitor in the face of any danger? Like if a dog in the premises should, get loosed off from the chain and jump on that visitor that maybe have come from government's area, quarters. Should there be any remedy for that visitor?
Of course, of course.
Who takes care of the damages?
The occupier. In fact, as an occupier, you owe a duty of care to this visitor.
All the occupiers where people live in flats, all of them are going to...
The law usually looks at the circumstances of the case. You mentioned having a dog.
Yeah.
So the law will look at who is the owner of this dog. And did he take care to see that damage is not caused to anyone who finds himself in these premises? So if such a situation, circumstances are analyzed, and it is found that the occupier, who in this case owns this dog, did not exercise reasonable care to ensure that the visitor is reasonably safe, then in such a case, he will be liable in damages.
Okay, thank you very much, dear esteemed viewer. This is Citizens and the Law on ABS Television, Channel 2 for Oka. You can also get us right now on Star Times 113 or Metro Digital 29. And with me here in the studio is Barrister BC Anyi from Nigerian Bar. The topic is responsibility to invited guests. Let's take a short break here. We are coming back right now. Well, there is viewer, this program is looking for a sponsor. In case you are interested in sponsoring this program, all you need to do is to call on 080-332-45290. Subsequently, I will get you the phone number of the commercial department. Right now, Council, still on this invitee stuff, are there conditionalities for being a qualified invitee? So what qualifies one as an invitee?
Yes, first of all, the person must have been invited by the occupier.
Mm-hmm.
So if you're not invited and you find yourself in the premises, the quality of invitation is lacking. Secondly, the invitee must be in the premises for a business which concerns the occupier. Now, let's say you find yourself there and now you're there for a business which concerns the occupier. The third question comes in, why you're there for this business which concerns the occupier? Are you limiting yourself
to that business?
To that business, yes. Because in most cases, you find yourself you're there, then after some time, you begin to deviate from the reason why you're there. In such a case, you're shifting from the confines of that invitee to another thing, which I'm sure will eventually come to. But once you move from there, you're no longer covered by the cloak of an invitee.
So since you are within the confine or environment of where you were invited, if anything happens to you, the occupier is answerable. But outside the specifications of the environment.
Yes, but each case must be examined depending on the circumstances.
Okay.
You have to examine the circumstances of each particular case to determine where liability lies, to also determine whether liability can be shared. Because there may be a situation where the invitee might be contributory negligent. And in such a case, liability will be shared.
Okay.
So that's the point there.
Well, there is one question I would have addressed to my police friend who is not here. Some people are in cell, some are over the counter. I think I have to leave that out. A policeman would have answered that question. But going ahead right now, we have some general overseers, we have some of Christian denominations, we have some reverend fathers, we have some pastors. They do what is called crusade. And at times you used to hear something like stampede. One thing or the other may lead to stampede. And we also used to hear that people dies. These people, are they not all invited? How does their relations begin to look for remedy? I want you to classify this further. People who attend to, who has the duty of care? Who has the duty of care on all those thousands of people invited? Is it the ministry that invited them, or the reverend father, the pastor, or the general overseer? Who is responsible for the duty of care?
Well, our constitution guarantees the right to life. And this right to life is not limited to the deprivation of life, but also it is extended to the sustaining of this life. So in the case you pointed out, in a crusade, the invitation is an open invitation. People gather and come. I believe that in such a situation, to determine whether action in negligence can lie, the circumstance of the case must be examined. For example, you have a space that has the capacity to contain 50 persons. And then you bring in 200,000 persons, or let's say 200 persons. There's a possibility
excess of 150.
Or 150. There's a possibility that there may be a stampede in such a situation. And again, too, in such a situation, there is usually the case of lack of internal coordination. For example, even where you have that 50 persons in that space, are you able to control the crowd? It has to be the presence of crowd control personnel. Because in most cases, in such a situation, there is always an atmosphere of anxiety that is created, depending on what is going on at that particular time. So when you analyze all these situations, and you find that eventually someone sustains injury or perhaps dies, there's an action in negligence in such a situation, because the organizers of such crusade, or even the persons managing the space, the management, they could also be liable. So if that happens, an action can be maintained against them. But you know, in such situations, there's always a whip-up of sentiments, because we're talking about religious activity.
Well, move away from the manager of the environment. Yes. Where direct your responses on the person, the immediate inviter, the immediate...
You mean the organizer?
Yeah, organizer of
yes.
the event that asks people to come.
Yes.
Should anything happen...
The organizer owes the duty of care.
Yeah.
persons who have attended, he owes the duty to ensure that the place is reasonably safe for them. He owes the duty to ensure that there is crowd management personnel, because you have to manage the crowd very well so that things will not go out of hand. And if he fails to maintain this duty, the duty will be breached. And when that happens, damage occurs.
We have to continue. Dear esteemed viewer, this is Citizens and the Law on ABS TV, Channel 2 for Oka. You can get us on Star Times 113. You can get us also on Metro Digital 29. And I have Barrister Annie BC here in the studio addressing the questions to this very topic of the day. I think I have to open the lines now. The numbers to call are 090-729-72090. The other one is 070-627-24192. I repeat, 070-627-24192. And also again, 090-729-72090. The topic is a responsibility to invited guests. Now you may continue, Counsel.
All right. I was saying that in such a situation where you've painted the picture you've painted, there may be a case where the person involved might not be willing to proceed to court.
Let's get this caller. Hello? 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 Please, if you want to call us, you tune down the volume of your TV set. The first thing you do is to tune down the volume of your TV set so that we can get you clearly. So go ahead, Counsel.
Yes. I was saying that the person involved might not be willing to proceed to court even when it's brought to, because there's damage has occurred, which was occasioned as a result of someone's default. So, but the person may forget that the aphorism, Justitia non novit patrec nec matrem solo veritatem specta justitia, holds sway in all situations.
This is either a legal or Reverend Father's jargon, the canonical language. We have a caller here.
All right.
Hello.
Hello?
Yeah, your name and location?
Hello?
Hello. 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 Go ahead. It's like the reception is poor.
All right. So justice knows neither mother nor father nor friends. So if a precedent is set, I believe that it will serve as incentive, if you like to call it that, to curb such negligent situations that might give rise to a situation where you organize something, you invite some people who are your invitees, then you fail to make sure that the environment is safe for them, to control the crowd very well, and keep to your duty of care. So that is that in that situation.
I'm bringing this thing down to our people.
Yes.
So that both the people inviting and those being invited should know it. Now you are in the studio. I want us to come down to various ministries who invite people. And let's assume that there is a pandemonium and people are running for their life, to save their lives. And some of them might fall into a ditch and get hands and legs broken or even die in the process. There is something the guest, the occupier, is supposed to do before inviting them. I think there are some level of carelessness on the side of our people. So that's the area I want you to go now. What are the measures a general overseer is supposed to take, or they are supposed to take, before asking people to come to an area for either prayer or whatever? Let's know if you can get this. Okay. Hello? Okay. So, your response?
Yes. I will still also repeat that the circumstances of each particular case must be examined. For example, you first of all have to ask or determine what caused the pandemonium. And then after that, you determine whether actually the general overseer or the person involved took adequate care to ensure that he maintained his duty of care. Because sometimes you would have gone beyond your measures to keep to your duty of care. but novus actis intervenit might come in. An external factor which is not your fault, it might come in to cause a problem. In such situation, you find that the person must have kept to his duty of care, but something else occurred. Or even a third party might come in to cause a problem. So in each particular case, the occupier must prove that he did all that is within his power to keep to his duty of care. So each circumstances must be examined.
Well, I don't know if our people are doing enough in terms of security of lives and property in crusade areas, because this duty of care either is coming from the government or the person that invited people. Precisely this issue of crusade, I'm not against it, but people must be protected if they come to the environment. Can you enumerate on the responsibilities of inviter to an invitee? Can you enumerate on the responsibilities? This is now lengthy. The responsibilities of an inviter to the invitee. What are the responsibilities? Hello? Hello? Yeah.
Okay. As an inviter, you owe what we call a duty of care. This is a term we've been talking about here.
Yeah.
You owe a duty of care to the invitee. Now, what is the duty of care? I always call to my aid one of the wonderful and lucid restatement of Lord Wilberforce in Merton's case, when he said that in determining whether a duty of care exists, it is not necessary to bring a particular circumstance in this case and apply it and think that it will apply in a case also where duty of care has been held to exist. But rather, the question you ask yourself is between the person who has suffered damage and the person who invited such one. Is there a situation of proximity and neighborhood between them? Have they been placed in a situation where the person who is the occupier can reasonably foresee that if he did not take care, damage would occur in such a situation? So that duty is very paramount. An invitee, again, also has certain rights, which is the right to find himself.
If you can get this caller. Hello? Hello?
Hello.
Hello, good day. Yeah. Good evening. Your name and good evening. I'm here. We are hearing you clear. Your name and location?
Uche from Amobia.
Uche from Amobia.
Yeah.
Okay, Uche, ask a question.
Your topic is interesting, and I want to also ask a question that is related to this topic, so not exactly the same topic.
Go ahead.
Now, if somebody, for instance, like if a party like JAM, Unity School, or any school at all, or any organization or government, invite people for examination, for a qualifying examination, and maybe I pass, and someone that has lower grade than myself is suspected and leaving me out. Have I the right to sue in this case?
You get the question?
Sorry.
Why I ask this question is that it is part of corruption in the country, it is in government, it is in organizations, it is in who you know and who you don't know.
Hello, Uche. Uche. Hello? Yes. Come again with that question.
Hello?
Come again with that question. Come again.
Okay. My question is this. If I'm invited for an examination,
yes,
maybe a qualification examination, either for promotion or admission into a school.
Yeah.
And I pass the examination, and somebody who have lower grade than myself is taken where I'm left out. Now, have I the right to sue that organization, whether government, JAMB, or an individual school?
You have to tell him, you have to respond to this. Whether he's fighting against nepotism or favoritism or tribalism or things like that. It's not within the confine of the topic,
It
but...
isn't, but
But
if
excuse
you...
me, let's know if we can get this caller before that. Hello? Hello?
Hello?
Yeah.
Hello?
Hello, tune down the volume of your TV set. Tune down the volume of your TV so that we can hear you. Yeah, good evening. What TV you were, but can you finish?
All right. Good evening.
Yeah, good evening.
My name is Uche from Oka.
Uche,
Yeah.
is that the same Uche that called us now?
Hello, huh?
Is that the Uche that called us now, or your namesake? The last caller said that he came to a place, he went to a place and took an examination, scored higher than some other people, but eventually the job or employment was given to people who scored much lower. Has he the right to now sue the establishment of the school or whatever organization that's set up that examination?
Well, let's say he didn't say, but assuming it's a private establishment owned by a sole proprietor.
Go ahead.
Yes, I was saying, assuming it's a private establishment owned by a sole proprietor, he conducts interview, gives a script to the invitees to write exams. He reserves the right to determine the criteria upon which he can take employees. It is his sole right. But for example, if it's a body like, let's say, JAMB or WAEC, I think there are internal procedures you can follow to actually prove a point. If you feel that you wrote and somehow you got higher score for someone who got lower was taken, but according to their set down rules, you merit what you're claiming for, you can follow it up.
Let's know if we can get this caller. Hello? Hello?
Hello?
Yeah? Your name and location? Some keys are in the house. Okay, Uche, you've had him. It depends. Number one, if that examination or something was set by private individual,
Yes.
or on the other hand, by something like JAMBO or GCE or something like that, WASC, West African School Certificate, the processes differ. The individual may decide the way he wants to do his thing. The other side, you may have to embark on some routines of getting at where it went bad. Then you will know what to do. But it's not within our topic anyway. Council, we're going to the next question. When will a guest or visitor be regarded as a trespasser?
Okay. When a guest
Or a visitor
will be regarded
as a trespasser?
First of all, let us consider who a trespasser is.
Yeah?
Trespasser is someone who enters into your
Hold it,
premises.
hold it. Hello? 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 Please go ahead.
Yes. A trespasser is someone who enters into your premises or remains in your premises without your permission
Yeah?
or invitation. In such a case, you call him a trespasser.
Yeah?
But in a situation where you invite him, he's in your premises, but suddenly he begins to go outside the confines.
Come again with your first point.
In a situation where you invite him, he's in your premises, but suddenly he begins to go outside the confines of his reason for being there. Then he's shifting from the title of an invitee to the title of a trespasser.
Yeah?
What readily comes to my mind is a case of Banigo and Banigo, where the court has decided that an invitee, once he moves from the main reason why he's in the premises to the reason why he's not there, he becomes officially a trespasser. So that is when an invitee can become a trespasser.
Can you cite examples of when a guest or visitor? There are two things. One is a guest, the other one is a visitor.
Let's say the example of the health worker. He's there, you know the reason why he's there, but suddenly he begins to leave the main reason for his visit there and begins to enter into your bedroom, for example, then you suddenly come in and you find him there. Ordinarily, your first reaction will be, he has no reason for being in my bedroom. So for that purpose, he is a trespasser. What he ought to have done is to first come, perform the acts for being there, and then leave. But if he leaves it and proceeds to another thing, he becomes a trespasser. We also have at hand the case of Okabu and others against Romain. These issues have been decided by our courts.
Okay. And we have a tradition in Africa. We have a tradition in Nigeria. We have tradition in our various villages. In fact, this issue of guests and visitors, I don't know to what extent it has been or is being practiced in our communities. Will a visitor ever be deemed a trespasser?
Yes.
How?
Yes. Well,
bearing in mind our tradition.
Of course, like I said, it depends on what, because I said he may move from the reason why he's there to another reason. What if he moves from the reason why he's there to a reason which is inimical to the activities of the occupier in the premises? So you may come and say, okay, you may have come and say, okay, he has deviated from this. But what he's doing now, well, even though it's not the reason why he's there, but he's still not dangerous to me, you can leave him. But what if he moves and proceeds to something that is inimical to the health of the occupier? In such a situation, he can be termed a trespasser.
I recently see in social media where a neighbor or a relation is feeding a baby with this Harpic liquid, with a detergent, and the baby was drinking it. How would you classify such person? Because he is known to that environment, familiar to the owner or the occupier, but now this is what he used the opportunity of being a relation to do. What does the law say in that area? Let's know if you can get this person. Go ahead.
All right. Assuming what you said is the way it is presented, or if it is the fact.
There are even some other aspects
let us work with the facts.
There are some other aspects of people who are given the contract of coming to pick the keys to the school and then bring them back again.
Yes.
There are some occasions when these keys are never seen again, and stories are told that he dropped them at the school. But when he went back to pick them again,
he never came back home with them.
Yeah. The school authorities answering questions that the keys were brought to them. They said, no, we never sell them. The gentleman or the hoodlum or whatever who claimed that he dropped the keys at the school never did. You see, these are two faces. These people are visitors' environment.
These examples are clear cases of what I've just been saying, leaving the main reason why you are somewhere and doing another thing. In these two cases, such persons are liable, either in thought or in the criminal aspect of it, if you examine the situation surrounding them. So these are facts. But whether someone a visitor or an invitee can become a trespasser is settled in law. The answer is yes.
Okay.
Yes.
Okay, dear esteemed viewer, you are watching Citizens and the Law on ABS TV, channel 24 Oka. You can get us on Star Times 113 or Metro Digital 29. And the topic we are handling here is responsibility to invited guests. In case you want to call and ask questions, the numbers are clearly written on your screen: 090-729-72090, 090-729-72090. The other one is 070-627-24192. We have a caller here. Hello.
Hello?
What separates a mere volunteer from an invitee? A mere volunteer from an invitee. What's the difference? What separates the two?
Okay, like we've been saying, an invitee enjoys the cloak of invitation, and in some cases,
let's know if this caller is serious. Hello. Hello?
Hello?
Hello, good day.
Hello?
Hello, your name and location? You might have to call us back. The reception is very clear, but then you have to call back.
Yes, but a volunteer is someone who, out of his own volition, accepts, even without payment, to act as your servant in a particular situation. In such a case, the person is a volunteer.
Yeah?
And another instance is also where someone who is in your premises.
Please don't be offended. Let's know if you can get it. Hello? Go ahead, please.
Yes, where someone is in your premises by virtue of an employment, which by the very nature of the employment, it can be taken that damage has been bargained for. So in such a situation, these persons are volunteers.
Yeah, is there any example to differentiate the two? Hello? Hello? Now, this volunteer and an invitee, is there any way you can, throw more light on the two so that the viewer out there can get it?
The volunteer is someone who works in your premises. The health inspector in the instance is not included. He works in your premises, and maybe the nature of the employment is engaged in is of such a nature that it is dangerous, but he still does it because he believes that he has to do it maybe to make ends meet. So in his doing it, he may occasion harm to himself, which may not be as a result of your default.
Yeah.
But the health worker is coming there because the law gives him the power to do so.
Excuse me.
The health worker is coming there because the law.
Sorry, go
The
ahead.
health worker is coming there because the law gives him the permission or the authority to do so. So the volunteer lacks the elements of invitation and permission, while the invitee enjoys the element of invitation.
Is this volunteer paid?
Of course, he's there by virtue of an employment, and you pay him
How then is he a volunteer?
because he accepts to do it. Ordinarily, you could say, I wouldn't.
I was thinking that somebody who volunteered to do something will do it free of charge, without payment.
Remember, I gave 2 instances. He's volunteering because without his volunteering, he wouldn't have been there. You have to invite him. You have to invite an invitee for him to come. But the volunteer doesn't enjoy your invitation. But he's there because he has to be there to work. And he must enjoy some element of consideration, which is the payment. The health worker, you don't pay him, but he's there. He has to be there because the law gives him the right to be there.
You may not like this question, but let us know how it will go. Somebody at the police barracks, either over the counter, in any aspect of detention, or in the cell, can he be regarded as a guest?
Someone at the police barracks.
Yes. Does the police have any duty of care? A lot of people have died in the cell. Some slumped down over the counter, and they were rushed to the hospital. Is there any remedy in such situation?
Now, let me start with someone who finds himself there.
Yeah.
Now, we have to consider the element of consent. He's not there because he has consented to be there, but because of maybe the situation which has brought him there. But even at that, while there's a duty of care to ensure the sustenance of his life. That is why the law provides for the enforcement of the fundamental rights of citizens. So if as a result of actions meted towards him at the station, he sustains injuries, he has a right of action under the fundamental rights procedure. And in most cases, our courts have granted such reliefs when they are approached with such reliefs. So even while you are in the police cell detention, there are some rights which you enjoy.
Somebody may be in the cell, and the criminals, hoodlums who are there with him, might beat that person, pop and blue, and are you going to hold him? Of course, you can hold the police authority responsible.
You've answered the question. So.
Now let's go to the stadium now. Let's go to the stadium. We have stadiums. Some of them are private. Some of them are owned by the government. Let's know if we can get this caller. Hello? Hello? This one is not talking. We have privately owned stadium and government-owned stadium. Can you look at the duty of care, both on the side of government and the side of privately owned stadium? You know, a lot of things happen in the stadium.
Of course.
Either by overcrowding and the step, anything can happen, it might collapse or something of that nature. Is there any precautionary measures that need to be taken under duty of care by government or the private individual who owns the stadium?
Like we've said, you, as a person who owns the stadium, you have to ensure that there is presence of internal coordination.
Let's pick this caller. Hello? Hello?
Hello?
Yeah, your name and location.
Hello, can you hear me?
Yeah, we are hearing you clear. Your name and location.
Okay, how is the content? I'm calling from Oka.
Anthony calling from Oka. Okay, Anthony, you may have to try again and you may get us. Okay, go ahead.
Right, there has to be presence of internal coordination. For example, you need to ensure that the place is not overcrowded because the damages usually occur first as a result of
Overcrowding.
So you have to ensure, and to ensure even when it is not overcrowded, situations might go out of hand. You have to ensure the presence of crowd control personnel. The crowd has to be controlled properly so that things will not go out of hand. These are some of the duty of care that you can exercise to make sure that people do not suffer damage as a result of your default.
Let's move a little bit to schools now. You do hear of schools collapsing and kids dying. Even residential area. Where do we apportion this blame? Because when something is not done the way it should be, then the devil has chances of coming in to do some dirty job. Souls have been lost in schools and residential areas. Whose fault is it over this duty of care negligence?
Well, these situations often occur.
Let me come. The way I'm talking is, government have somebody whose responsibility is to ensure that the foundation of the house is solidly built, that the erection is solidly made. In absence of this, buildings collapse. Who has failed in the duty of care? Is it the government or the direct owner?
Well, you can share the liabilities when you examine the case. For example, government has to ensure that before you commence a building, there are some procedures you undergo to ensure that the place where you want to situate the building is fit and habitable. These are...
Let's know if we can get this caller. It's gone. Go ahead.
So these measures can be implemented by putting some laws in place. And I believe there are some laws too that take care of that. So before you build, you come and the place is assessed. So that the aim is to prevent any damage that might occur in the future.
Hello? Please, you may go ahead.
Yes, but after these measures have been put in place, and yet, unfortunately, something happens, there has to be an inquiry into the cause of the collapse. And when the result of the cause comes out, then the persons who are found culpable should be dealt with according to the law and the provisions therein.
Is beware of dog sign tag on gates of occupiers enough to stand as duty of care measure? You see, beware of dog. Let's know if you can get this caller. Hello? Hello?
Hello?
Yeah, good evening.
Hello, good afternoon. My name is Franklin. Hello, can you hear me?
I'm hearing you. Franklin from where?
Yeah, good evening.
Come again. Your name?
I'm calling from Walker.
Okay, go ahead with your question.
My name is Franklin. I'm calling from Walker.
Okay, we've had you. Go ahead with your question.
Okay, please. One of my friends is as a graduate and is a first class. So then we never see him.
Tune down the volume of your TV set so that we can hear you clearly, Frank. Please, if you are calling us, you make sure that the volume of your TV set is tuned down reasonably so that we can hear your voice, so that your voice can be clear. So, Council, we don't have time anymore. In front of some gates, we used to see "Beware of Dog." This "Beware of Dog" sign on gates of occupiers, is it enough to stand as duty of care measure to people who comes there as visitors or as guests?
Well, this is usually the practice. You go some places, you see that "Beware of dog," beware of dog. Mm-hmm. But truth be told, in most cases, this sign has served to protect to an extent some persons who are passing by, because once they see it, they are immediately at alert and they know how close they come to the gate or how far they can be. But the truth of the matter, and in law, is that such a sign is not enough to absolve the occupier of liability. I also want to call to aid the Law Reform Torts Law 1961 of Lagos, particularly Section 8 sub 2, which provides that where damage is caused to a person by danger of which he has been warned, such warning shall not be treated without more as absolving the occupier of liability. So where I come into your premises, even though there's a sign, "Beware of dog," and I eventually occasion harm, the position of the law is that the occupier must go further to prove that such warning is reasonably enough to ensure my safety. Let's say, for example, I see the sign, then I enter the premises. I've seen the dog is in a cage, and I go further to unleash the dog. The occupier can say that it is not his fault that this damage has occurred, because the visitor or invitee did something which he ought not to have done. But most times when that sign is there and harm occurs, if the occupier is not able to show that such warning is enough to ensure the safety of the visitor, he will be held liable according to that law. So there's a litmus test which must be passed before that can avail.
What if this knowledge of the dog's propensity to bite is not known to the occupier? What happens?
The knowledge of the propensity of the dog
to bite
is not known to the occupier.
Because anything can happen anytime.
Yes, but how safe has the occupier protected the visitors or invitees? You know that there is the dog. You don't know the propensity of the dog which you keep in your premises. It's a question of fact and evidence which you have to prove. Because someone who brings into his premises something which a reasonable man sees as dangerous cannot ordinarily come and claim that he doesn't know that this is dangerous. So he has to prove it. That is why I said that he must go an extra mile to show that the warning is enough to safeguard the visitor.
What of those who fix beware of snake?
Actually, I haven't seen that, but well,
what does the law say?
He cannot absolve the occupier.
Okay.
He cannot, because the snake is inherently dangerous, and you ought to know that you don't have to keep it. But when you keep it, you have to take care that it doesn't cause harm to your neighbor.
So people who keeps tamed wild animals, some of them are tamed in their house for security measure, they can say beware of lion or beware of leopard. So, should anything happen, does the law give any consideration at all?
Well, if you do that, the degree of duty of care you have is higher. Because when you keep a wild animal, you are expected to go extra mile to ensure that such an animal doesn't cause harm or havoc to anybody. So the degree is higher.
Now, you say that the landlord is both an occupier and owner. and other tenants are co-tenants. What if one of these tenants, one of them, newly packed into the premises with a very wild dog, or with something like these snakes or tigers we are talking, and they are in a cage, and they live together? For the visitors who come to visit those people living there, who has the duty of care?
Sorry, let me get. I said that there can be more than one occupier, and someone can be an occupier even though he's not physically present.
Yes.
So just bringing the question
The
again.
landlord is both the occupier and the owner.
Especially when he's not physically present.
Yes,
Or
and
when
there
he's
are other
present.
occupiers.
Yes.
Somebody now packed in with the lions and the snakes and all that,
This is the premises.
as is termed the wild termed animal. Should anything happen, which of the occupiers will be held responsible? The landlord who allowed him into the premises, or the person himself?
The person keeping the animal,
The termed wild animal.
the tamed wild animal, will be liable.
The landlord has nothing at all to answer, because he collected money from him, knowing fully well that he has those wild animals with him.
Well, the situation is such that the blame can be shared, because as a landlord and where you are also an occupier, you owe a duty of care. Both the person who brought in the wild animals and the landlord.
Would you have, I put you now in a position of a landlord. Can you allow somebody who has wild animals, tamed or not tamed, to live in your house with other tenants? Can you do that if you're a landlord?
Well, if there are adequate provision for keeping the wild animals, why not? But if a situation where there is no adequate provision, and you know reasonably and you have foreseen that because of this lack of adequate provision, these animals can cause extreme havoc to other occupiers, I wouldn't, unless there is adequate provision to keep them safe.
Well, for me, under all circumstances, they say that the ocean does not swallow somebody whose feet it did not see. It's better not to getting near the ocean, not to talk of the person is drowned in the ocean. So there is Tin Viewer. On this note, we've come to the end of today's edition of Citizens and the Law on ABS Television, Channel 2 for Oka. It has been Barrister Annie BC here in the studio with me addressing the questions. So, Counsel, thank you very much for coming.
My pleasure.
And I am Jude Mascot of Biagu, the presenter of this program. Next week, we are coming back again with another interesting topic. Until then, bye for now.